This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are talking with Professor Joshua Hawley, former clerk to Chief Justice John Roberts, author of Theodore Roosevelt, Preacher of Righteousness, and he is currently an associate professor of law at the University of Missouri. Josh, welcome to the show.
Thanks very much, Richard. Good to be with you.
Josh, you wrote an essay most recently in the journal National Affairs entitled The Most Dangerous Branch, which I thought was quite unique. You begin with the decision, National Federation of Independent Business versus Sebelius, which, as we all know, upheld Obamacare as constitutional under the tax power. And you write, you mentioned this decision in the opening, but I thought it was interesting. It wasn't to criticize your former boss and the move he made or the majority decision, but you write about the sense of anguish, of betrayal, and also conversely the elation supporters of Obamacare felt after the decision. And I wanted to read an opening from the essay because I think it really sheds light on what you're doing in this essay and the larger principle you're trying to discuss. You write, quote, "Conservatives' reaction was laced with a certain bitterness, a deeply felt, almost personal anger at the court and its justices, particularly Chief Justice Roberts. This sense of betrayal was moved not only by a conviction that the court had gotten the law wrong, but also by disgruntlement at having lost a profoundly important political battle and at the hands of a supposed ally. While conservatives surely have cause to be vexed with the court for its legal judgment, it is the sense of betrayal that exposes just how dangerous the court as an institution has become. The true peril posed by the Supreme Court in our time lies in the idea that the court can ever serve as an ally, that it can resolve political difficulties, and that it can be counted upon as a political partner or an agent of political reform. It should do none of those things, and it threatens our constitutional order precisely to the degree that it attempts them." How so?
The court, I think, it is, in the words of Alexander Bickel, or in the paraphrase of Alexander Bickel, a counter-majoritarian institution. And just to press that insight, I think it is a great insight that we would do well to think more on and recover. To press that just a bit farther, the court, I think, has the unique capacity, the United States Supreme Court, to remove questions of disputed constitutional issues from the public realm, from the realm of political debate, and to move them from that realm into the realm of law, where, of course, it is supreme. And in so doing, in removing these issues from the realm of politics and public discussion, the court potentially drains away the democratic authority of the people to decide these questions and really to be participants in constitutional interpretation. And I think over time that is a dangerous thing. And the healthcare case, the Affordable Care Act case, I think is a good illustration of the perils, as I say in the essay, of looking to the court to solve what are really political problems. Now, that's not to prejudge the constitutional issue or to judge the constitutional issue one way or another. And the Affordable Care Act case, I tend to think that the act should have been, the individual mandate should have been struck down. So I disagree actually with the Chief Justice and the majority's decision. But the broader point, I think, is that it is a dangerous thing to look to the court to solve what is essentially a political dispute. Precisely because doing so, asking it to intervene in that way, is to give to the court power over what are essentially political issues, which may be helpful to the winning side in the short term, but in the long term tends to consign more and more democratic authority to the court.
You have this principle that you talk about, others have talked about, popular constitutionalism. Within it rests a distinction, constitutional politics and constitutional law. And you argue more and more within our political disputes, we consign them to the realm of constitutional law, where they kind of receive this fixed judgment typically placed on some sort of almost universal principle that marginalizes those whose in effect position fails, and of course exalts those who succeed at the court. And you argue we need constitutional politics. Let me ask you, what's the difference between those? We need a constitutional political system versus a constitutional law. How do we know the difference?
I regard constitutional law as the minimum baseline that every participant in the American political system, every political actor, has to accept as the legitimate foundation of the constitutional order. So it is a minimum content that is not subject to political dispute, at least not in any strong sense. Constitutional politics, on the other hand, I think embraces the realm above and beyond law. It certainly embraces constitutional principles. It involves disputed constitutional matters, but constitutional politics is about how do we apply the baseline of the law? How do we apply that baseline to current controversies, disputes? How do we make sense of portions of the Constitution itself that seem to be opaque, that are subject to multiple different interpretations and multiple different applications? That I regard as a more discretionary realm, and I define that as the realm of constitutional politics. And I'm glad you asked the question, Richard, because this distinction between politics and law, of course, is very familiar in American history, and it's very familiar among constitutional scholars today, but scholars use it in quite different ways. And just to take an example as a contrast, Jack Balkin has recently written a book called Living Originalism, and he uses these terms as well, but in a very different way. For Jack, constitutional law embraces much of what I call constitutional politics. He thinks that constitutional law should settle disputed issues of constitutional principle. He thinks that the courts are legitimately players in this realm, and he sees a different sort of interaction between people and courts that I do. So, again, I think that constitutional law is the minimum baseline that actors have to accept in order to participate in the system. And when you define it that way, you see what the danger is in permitting an institution that turns politics into law, namely the Supreme Court, to have more and more authority, to have greater and greater purview over disputed issues, because to the extent that the court makes those issues its own and rules on them, it turns the issues into law. It turns them into that baseline that then is beyond the realm of politics, and in so doing moves them out of and beyond political dispute. And that, I think, again, over time, can be quite a dangerous thing.
Certainly, in thinking about your argument, there's also something else happening, which is we lose the habits of Republican self-government, but we also lose the habits of compromise, I think, in this realm of constitutional law, and that is these decisions are handed down, and it's hard to remediate them. It's hard to, in effect, allow those who lose to feel increasingly that they are still a part of the issues they care about, the debates that they make, because that they participate in, precisely because these decisions are so unilateral. And I'm thinking of the upcoming decisions on California's Proposition 8, which made same-sex marriage unconstitutional in the state, and then also the Defense of Marriage Act, where since marriage law potentially for the entire country could hang on 5 justices, and in particular the vote of Justice Anthony Kennedy, which just seems, it should seem, I think, bizarre to people, and yet here we are.
And I think that's a great point, that it should seem bizarre to people. I mean, just think about that for a moment. It seems a strange way to do business in a democracy, that a question that the United States Constitution does not address, that is, namely, what is the substantive definition of marriage, a hugely fraught question to which there are moral principles bear on this in very significant ways. There are very profound arguments on both sides, and on all sides, indeed. I think there's probably more than 2. This seems like a very fundamental question for the identity of the political community, both the states and then more broadly the nation. And yet we have the very real prospect that this very fundamental question, hotly disputed, not directly addressed in the Constitution, will be decided by a single vote of an unelected member of the judiciary. That just seems, when you put it that way, it seems like such a bizarre way to do business in a democracy. And I think that considering the question in that light points out just what a strange place the Supreme Court occupies in our constitutional system. Structurally, you might think, and one might wonder if actually, thinking in terms of our constitutional structure, if the Supreme Court now occupies a role in that structure that is different than the founders either anticipated or could have imagined. Perhaps we can come back to that. But I think that you're quite right, and the prime example of the dislocations, the democratic dislocations, that the court's activity and the court's intrusion into political matters in this way produces is, of course, Roe versus Wade. And again, what everyone thinks of the substantive question of abortion policy and the right to choose, I think that it's very hard to argue at this remove that the court's intervention produced a severe pathologies in our democratic system that are still being worked out. Precisely because it prevented a democratic resolution of the issue. It prevented the people from discussing among themselves, from arguing substantive moral points and equality points among themselves. It prevented them from reaching a resolution. And, of course, the negative ripple effects have extended to the court. Much of the politicization of the judiciary in the 1980s and the 1990s, I think, can be more or less directly traced to Roe versus Wade and to the increased heightened public consciousness that the judiciary does indeed have a profound effect on what most people consider popularly political questions, and that therefore the public wants to have more control, certainly the political branches want to have more control over the court, which leads them then to take a greater interest in nomination hearings, to more closely screen nominees for political preferences. And so there's a negative feedback loop, if you like, all stemming from the court's attempt to settle what was in 1973, and I would argue is today, a political issue.
I ask you, so much of your argument, as I'm thinking about it really, you write about the court in the first century hearing perhaps 24 pure constitutional law cases and ruling laws passed by Congress unconstitutional on 2 occasions. And it seems so much of this is a question of how one thinks of the Constitution as a whole. That is, are protections for liberty, protections for the rule of law, a matter of structure, a matter of ordering principles in separation of powers, federalism, or is this really a rights-based document? And so much of that emerges, I think, with the 14th Amendment and the reading of the 14th Amendment that also comes about in the mid-20th century, which you write about as this idea of really the fundamental rights being a part of the Constitution's purpose, or the major purpose. And of course, also part of that is a court ruling that there really are very few limits to the power of Congress to regulate matters, to impose laws as it sees fit across the country. And so there's kind of really a shift in constitutional understanding or thinking what the Constitution does.
I think that 2 things happen after the 14th Amendment. One of them is that the court relatively early on, and certainly by the second half of the 20th century, the court decides that it is going to be the principal enforcer, perhaps even the exclusive enforcer of the 14th Amendment. So one can make a good case that the drafters and ratifiers of the 14th Amendment saw Section 5 of that amendment, which of course gave enforcement power to Congress, as the principal means of the amendment's enforcement. Indeed, John Bingham's first draft of the 14th Amendment was purely an enforcement provision. It wasn't self-executing originally, which the other drafters thought was a problem, and so they separated Section 1 from what became Section 5. But I think that this betrays something quite fundamental, which is that the 14th Amendment Congress, and likely the ratifiers, of course the ratification of the 14th Amendment is an interesting question in and of itself, but the drafters imagined the amendment being enforced and therefore I think interpreted principally by Congress and thus the people through their elected representatives. The court is going to decide as early as the civil rights cases, but really coming to a head in the second half of the 20th century, that it is going to be not only the principal, but more or less, by the time we get to the Birney decision, the exclusive interpreter of the 14th Amendment and the exclusive arbiter as to what counts as rights under that amendment and what its various provisions mean. This is a big shift that I think, again, the drafters did not anticipate, and that would have been even more difficult for our framers of the original 1787 Constitution or the Bill of Rights a few years later to have anticipated. The second thing that happens, which you alluded to, is that the court, at the same time it's deciding that it will be the first word, the last word, and the final word on the meaning and enforcement of the 14th Amendment also settles on an interpretation of that amendment's rights provisions that are extremely nebulous and open-ended. And this is the substantive due process move that the court makes. It flirts, well, more than flirts with, in the Allgaier-Lochner era at the turn of the century, under the guise of its police powers jurisprudence, and then revisits with gusto beginning in the 1960s and continuing right through the present day, such that the substantive due process line of jurisprudence is one of the most fertile, if you like, sources of jurisprudence of constitutional law today. And these things in combination, the court's insistence that it's going to enforce the amendment itself and speak first and last, and then its interpretation of rights that is so divorced from either the text of the document or the original understanding of the document, I think has served to elevate the court, again, to thrust the court into live political controversies and to drain away the authority of the people to interpret these disputed matters for themselves.
Bernie, you talk about this decision in the case, and I guess I've always thought when the court reacting with the people at their backs, it seems, after the very adverse decision or perceived adverse decision to religious liberties in the famous the Smith decision with regarding peyote in the state of Oregon, and the ruling being in effect a neutral rule, not passed with any hostility to a religious group, would not violate First Amendment religious protections, and then the court comes back, the Congress comes back and tries to remediate that. Of course, a lot of state legislatures do as well, but the Congress doing it under the Fifth Section. So is the way back the Congress repeatedly trying to assert powers under the Fifth Section of the 14th Amendment, and the court finally being chastened after repetitive attempts?
I do think that Congress should take a more aggressive role in attempting to use Section 5 to interpret and enforce the liberties and rights guaranteed in the 14th Amendment and through the 14th Amendment. And I think that there are members of the court, I think, who both in the Bernie decision and subsequently have felt some disquiet about the almost imperial role that the court casts itself in that decision. And so I do think that one possible road, I don't know back, but forward, is for the court to regain some balance, I think, in our system structurally, is for Congress to invoke its Section 5 power. And I think the court, and this is something that scholars ought to address themselves to in a more serious way and focused way, the court needs a principled methodology that will permit them to recognize Congress's judgment, particularly under Section 5, and to accord it the respect that it deserves. Justice Kennedy in the Bernie case raises the specter of Congress just saying that the 14th Amendment means whatever Congress thinks it means. And of course, that can't be right. The court does certainly have obligation to review what Congress says and what Congress attempts to enforce. And so the court is in need, I think, of a principled methodology for discerning when is Congress's interpretation of the 14th Amendment, Section 1, a principled, viable one? When is it not? When should the court defer? When should it reject? And I think that is something that scholars ought to help the court with, if you like, and address themselves to. It would be a great service.
Well, several parts of your essay really return us to the ratification of the Constitution, the contest over ratification, as well as thinking about the scope of judicial review. And I want to revisit this part because I think it's really important. So Alexander Hamilton announces in the Federalist Papers, or argues that the Supreme Court, and he says this famously, will be a branch chastened by the executive branch, by Congress, and we shouldn't really be too concerned about its powers. Anti-Federalists, which you quote Juan Brutus, but also Federal Farmer, are much more worried, and you quote Brutus in one letter about the judiciary. They are independent of the people, of the legislature, and of every power under heaven. And yet Hamilton has this famous line in Federalist 78, quote, the job of the Supreme Court to declare all acts contrary to the manifest tenor of the Constitution void. And I wanted to get your thoughts on that sort of comparison. On one level, Brutus seemed right. Hamilton seems wrong as the way things have played out. And yet there seems to be something very important Hamilton is saying there about judicial review and manifest tenor of the Constitution, that's what the court should limit itself to. It's only striking down acts which violate that sort of palpable, uncontested sense of the Constitution. And in that regard, the court really is only a counter-majoritarian institution. It is, in effect, one of the auxiliary precautions talked about by Madison and other parts of the Federalist Papers.
I think that Hamilton, it's unclear, of course, just from his few lines in the Federalist, how extensive he regards judicial review as being, or anticipates it as being. He's one of the few people who seems to anticipate judicial review as judicial invalidation at all. And it's unclear from his comment about the manifest tenor if he thinks that the entire, just to think about the scope of it for a moment, if the entire act is to be invalidated, or if this is more like a choice of law provision, which is really, of course, how Chief Justice Marshall characterizes it in the Marbury case, that really when faced with different sorts of law, one of which propounds a rule that would address this particular situation before the court has to ask itself, is this the right law to apply, or is there a different law that reaches a different answer that is somehow privileged? And Marshall seems to say, this is a familiar question in choice of law, that you have to choose the Constitution, of course, if there's some conflict. Now, that does not necessarily lead to the conclusion, of course, that the whole statute has to be invalidated. It may just mean that in this particular, more something closer like what we would think of as an as-applied challenge today, that in this particular situation the law simply cannot be applied. That is, the statute cannot be applied because the Constitution trumps, and the Constitution seems to announce a different rule. So to come back to Hamilton, it's unclear to me if he is embracing that principle or something broader. I tend to think it's probably closer to what Marshall had in mind. But as to your point, Richard, I agree with you. I think that whichever interpretation of the scope of judicial invalidation that you think Hamilton's referring to there, he certainly seems to imagine the judiciary doing it only if there is a very clear conflict between the manifest tenor of the Constitution, between the rules and standards and principles announced there, and the statute, the act of Congress or other branches that is in question. And I think it's hard to argue that the contemporary judiciary limits itself to that mode of judicial review.
But you say there's also a question, I think, of progressive constitutionalism, which is, I think, inherently your opposing partner here, although there are other ideologies at work. But progressive constitutionalism, that the Constitution, of course, the familiar refrain of it grows, it develops over time, but there really are these constitutional milestones, rights, entitlements, benefits, which we don't question, we don't change. We're involved in a historical project of political articulation that we're not going to revisit. Why? Because that's in the past now, and we're already moving forward again. And so for you to bring it up or to question it is, in effect, a commentary on your bad faith upon your bad motives. And it seems in effect, that's what one confronts now in dealing with these decisions, either on individual rights or either growing entitlements like Obamacare and others, that this is a part of a project of articulation, of political articulation, and they're laid down, and this is really the new moment of or the new idea of constitutionalism.
One of the strange things about living constitutionalism or progressive constitutionalism, particularly, let's say, in the Bruce Ackerman style, this idea that there are constitutional moments, constitutional settlements, higher lawmaking, he says, occurring usually through the Supreme Court, reflecting a political realignment that results in a new mode of constitutional interpretation, if not an entirely new constitution. So one of the strange things about that is, as you say, it tends to actually lock in and treat as sacrosanct these past decisions, and it actually means that living constitutionalists end up holding a position that they're always accusing originalists of holding, which is the position of saying that, well, that's settled. We can't actually go back and revisit it. I mean, we can't actually question anything. That's a settled thing. Of course, they say it not on the basis of the original meaning, but on the basis of these supposed constitutional moments in Ackerman's case, or other decisions of the people in Jack Balkin's case, or Sandy Levinson, who have a somewhat different version of this same theory. So I think, strangely enough, or maybe counterintuitively, it's actually originalism properly understood, which recognizes that the Constitution does have real content. It was meant to embody real principles that meant something at the time that they were drafted, but that also those principles and the definite commands of the Constitution are limited and leave much scope to the political branches. It's originalism understood in this way that actually leaves more room for genuine development, including the revisiting of older debates, earlier wrong answers, if you like. It allows maximum, I think, flexibility, or at least more flexibility for the political branches and for the people to exercise their democratic prerogatives than, ironically, over time, living constitutionalism does. And I think that that's a point worth making.
You argue that, in effect, our Supreme Court is operating in the manner of elements of the Virginia Plan, the famous Virginia Plan. James Madison, it's largely attributed to him, although he's not the one that introduces it, in the Constitutional Convention, in the respect of the Virginia Plan had a Council of Revision, which would allow the president and a council to veto congressional laws, and then we also had a congressional veto over state laws. Both of those were struck down in the course of the convention because they seemed to provide or short-shrifted the states in the new constitutional order, and so many parts of the Virginia Plan it's seen as an overreach of federal power. Yet that's how the Supreme Court seems to operate in both respects. And I had thought of it in that regard. But I think you're largely right there.
And this is a structural point that I think conservatives and libertarians would do well to dwell on, because while we have, I think, been very concerned in the last 30 years, particularly with judicial methodology, and there's no doubt that judicial methodology is important. Institutional considerations, institutional role, I think, is also critical for explaining and understanding the behavior, and ultimately for constraining the behavior of the judiciary. And one of the troubling things structurally is that the Supreme Court has come to occupy a place within the constitutional order that is, as I argue, akin to a combination of the Council of Revision and the veto-wielding Congress, the state veto-wielding Congress. And partly this is because of the institution of judicial review that Marshall discovers, and then that is expanded to include full-throated judicial invalidation, a very, very robust form of judicial review. And then also the developments later in the late 19th and early 20th centuries that we spoke about earlier, with the court coming to see itself as the principal interpreter and indeed enforcer of national rights, and then at the same time embracing a very nebulous open vision of those rights. Those things together, I think, have put the court institutionally in a role that the framers imagined briefly might be occupied by a Council of Revision or by a veto-wielding Congress. And the question that scholars, I think, need to think about, people of goodwill who are concerned about the court's role need to think about, is not just what judicial methodology will appropriately constrain judges to the letter of law and uphold rule of law principles, but what sort of institutional changes might need to be made in order to return the Supreme Court to its proper role. I propose in the piece a very radical one, mostly just as a thought experiment, which is to make membership on the Supreme Court temporary, such that federal court judges drawn from the federal appellate, perhaps district courts, would be, by lottery, rotate onto the Supreme Court and would serve for a limited period of time, be it 2 years or 3 years or 5 years, and it would return to their prior posting on the inferior courts, and so on and so forth. This rotation would continue indefinitely. The thinking behind it is this would be one way to change the institutional incentives that Supreme Court justices currently have. It would make it very difficult for a justice, for instance, to say to herself or himself, well, I know what my ruling means in this case. I know what the principle should be. I'm here on the court to interpret it in future years, and therefore we can risk intruding ourselves into this particular area. We can risk announcing a new standard, the application of which is going to be very unclear in future cases, because I will be here in order to see that it's interpreted right, or I have a majority, et cetera, et cetera. I think justices would be far more hesitant to announce sweeping rules of law to place themselves in the middle of political controversy if they knew that they shortly would no longer be on that court and would be back in the position of enforcing and obeying its rules as a member of an inferior court. In any event, that's just one proposal. I think that the broader point is whether we make drastic institutional changes of that sort or not, scholars and conservatives, libertarians need to think carefully about the institutional incentives that are currently contributing to the court's behavior.
I'm glad you brought that up. I was going to actually I wanted to read that part, but you've described it well, because it was fairly radical, but I also thought it was worth considering. Have you had any reaction to that at all, or any response? It certainly is something I haven't read before.
I think that polite silence would be the best description. I don't know if I'm going to be invited to lunch at the court anytime soon. Yeah. I think that it is making a change as drastic as that. Well, actually, I don't think it would require a constitutional amendment. I think it probably is compatible with Article 3 as it's currently written. It would require, obviously, a statutory change. It's hard to imagine. It's hard to imagine fiddling at all with the institution of the court, and there are good, I think, reasons for that. But I think again, for those of us who are concerned about the trend line and concerned about structurally, and not just concerned about the result in a particular case, but structurally are concerned about the role that the court has come to play, I think it does behoove us to try and, through proposals like this one, other sort of, I feel like almost counterfactuals, to try and imagine the Supreme Court in different lights and ask ourselves, is the current institutional role the court occupies, is that the only possible one? Surely not. Surely there are other possible institutional roles for it. And what might those be? What might they look like? And then how might we, in ways large or small, how might we begin to shift the institutional incentives?
No, I like that, and you're right about the incentive effect, but also, and you've kind of been talking about this, but there's a relativizing effect as well. I think in that it would make the Supreme Court look not so much like a place of high Solomonic wisdom, if you want to use that phrase, and actually something where a lot of different judges, federal judges in the capital of your state, et cetera, or the district where you reside, actually now are on the Supreme Court, and so it does seem more of a court that's not necessarily removed, I think, from political battles, which seems to give it this credibility. And when it does make these momentous decisions, you write. I wanted to talk about originalism and the ideas that we've been discussing, because you say on one level, originalism isn't enough, and yet you also seem to argue it should be the dominant mode of constitutional interpretation, with the distinction being, if originalism really can't find an answer, a conclusive answer, then the conclusion should be Supreme Court should just step back and let the act rest.
I think that originalism as a methodology for fixing constitutional meaning, I think that originalism is the best we've got. It has problems. It's difficult to apply in many circumstances because it's difficult to fix often the historical meaning, and there's all sorts of, I think, very important questions that are still very much open within that methodology as to who exactly we should be looking to fix the meaning, whether it's the public at large or drafters or ratifiers. I think those are actually very difficult questions. However, with all of that in view, I still think originalism is the best mode that we have if we're going to take the written character of our law seriously, the written character of the Constitution seriously. And I think some mode of originalism, some form of it, is just inescapable as a form, as the proper form, I think, at least mostly for constitutional interpretation. But my point is that I think originalism as a method of discerning the meaning of the constitutional text is, in and of itself, not enough to constrain the judiciary in the way that they ought to be constrained, but also even as a methodology, as a judicial methodology, it needs, I think, to be supplemented with attention to the judicial role. Because originalism, of course, is something that can be done by law professors or lawyers or others, but judges occupy a particular constitutional role in our system. And so I think originalists need to think seriously again and more about the role that judges play and what that might mean for applying the originalist method. And my own suggestion is that judges need to adopt, if you might, like something like a clear statement rule, almost not quite that strong, but they need to look for clear meaning in the document if a meaning of a particular provision or if its application, the application of a particular provision to a current controversy is indeterminate, then that is an appropriate place for deference to the political branches. And beyond that, I think that ought to be, I hope, relatively uncontroversial for most originalists. Justice Scalia has, for instance, said something very much like this, and Justice Thomas as well. But moving even beyond that, I think that originalist judges also should be attentive to the effects of their decision rules, if you like, on the operation of the political branches. And so judges ought to craft decision rules that will leave open the channels of democratic participation and democratic debate. And that is an appropriate function of the judge. So that concern for the institutional role, I think, is an appropriate part of a broader originalist methodology. And it goes beyond just fixing or discerning what the original meaning of a provision is.
No, I think that point's well taken, because as I read your argument and listen to you discuss, I mean, really what you're bringing back is something Publius discusses, is the deliberate sense of the community, allowing that process to form, litigate, and really settle constitutional meaning amongst representatives, and of course in a process of debate and discussion with the people they're representing, and also various institutions. I mean, you mentioned at one point the election of 1800, of course, and this is right an enormously important election in the history of representative government, in the history of our own constitutional republic, and yet it's settled through deliberative democracy. And of course, fast forward 200 years, we have another contested election settled in a very different way, using equal protection jurisprudence to resolve it. Thinking now, these enforcement rules that leave wide discretion to the representative branch. I mean, how would that work, or have you thought about it in sort of these hotly contested matters that are coming up, or religious liberty cases? It seems to me one can see more openness on questions of federalism, separation of powers, but these are really the hard cases where the rubber meets the road.
I think that the court should look to some of its jurisprudence and its lines of reasoning in other areas. For instance, in the political question doctrine, the court often speaks of judicially manageable or unmanageable standards. And in the test that I do not like, the Lemon test, which I think ought to be rejected as an interpretation of the First Amendment, but nonetheless, as part of the Lemon test, you'll remember the court asks about entanglement, and the question there is, would the government, whatever branch of government or level it may be, would the government become entangled with religion because of a particular practice or question at issue? And these, I think, are telling and helpful ways of thinking about the court's involvement with political questions. So I think the court ought to ask itself something like that when it faces a question of significant political import, which is that what rule will, first of all, is there truly a judicially manageable rule here? And will the court's involvement or will the scope of the decision rule unduly entangle the judiciary with the political process? And so it may be that what we might think of as a form of underruling, constitutional underruling, is appropriate in some cases, precisely in order, again, to leave open democratic channels of participation. Now, this is something I think that needs more thought and attention, but again, it's important, I think, to supplement the original meaning as a methodology of fixing the meaning of a particular text with attention to the judicial role. So just to on the religious liberty question, for instance, back to the Bernie case which involved RFRA, the Religious Freedom Restoration Act. In that case, I think you can make a very strong argument that when Congress has gathered much information, held hearings, talked to its constituents, and has reached a judgment for itself that that the decision rule that the court announced in Smith was not the best way to enforce, was not necessarily the best interpretation of the First Amendment incorporated through the 14th Amendment and those guarantees, that the court owes Congress, at the very least, it owes it the consideration or it owes it the respect of considering Congress's alternative rule. And so Congress, I think, in that case was proposing not to replace the First Amendment's meaning with something else, but to propose a different decision rule, if you like, for the court. And the court, of course, declined to even consider Congress's alternative decision rule. And this, I think, is an example of where the court would do well to heed the political branches, and either to take Congress's disagreement as an occasion to revisit its own earlier decision rule, announced in Smith in this case, or, a bit more strongly, to defer to Congress's alternative decision rule so long as it is not manifestly inconsistent with the text of the Constitution and the substantive guarantee. So that's one way in which this might work, but I think even outside of the Section 5 context, the court ought to be asking itself, do our decision rules unduly entangle this court in the democratic process, or do they leave open ample channels of communication, if you like, ample means of democratic participation?
Josh, I think this is a good stopping point. Thank you for this really wonderful essay, The Most Dangerous Branch in National Affairs. I think it was the summer issue of 2012. I'll be linking to it on the website. Thank you for joining us and talking with us today.
My pleasure. Thanks for having me.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.